So has your patent application or your trademark application been rejected? It's a common part of the process. I wanted to do this video to help you because often when you file an application, no matter how many times your patent attorney or your trademark attorney might have told you that it's not going to go straight through, it does seem to me that there's always a hope or an expectation, maybe not always, but often, so that it will go all the way through without any pushback at all. And then when the pushback comes, it's very natural and human to be disappointed, discouraged, and sort of be thrown into the valley of despair. So I wanted to do this so that if that's you, if that describes you, let me explain what the rejection actually is and help you get out of the valley of despair. So what is the rejection when a patent or a trademark application are rejected? In both cases, it's not the end of the process, it's the middle of the process. So there is an expectation, especially with patents, there is an expectation that there will be pushback. And with patents in particular, we want that pushback. We want prior art rejections because we want to know that we have claimed broadly enough in most cases. So your case might be different, but most clients are looking to get the broadest coverage that they can get, the broadest claims they can get. And so if your patent application goes through without any pushback at all, what it means is we don't know how much design around room is left between where your claims end and the next prior art starts. So that's not a good thing. When we get prior art rejections, it creates a record and it helps us see where your claims overlap into the prior art so that we can then, in the process of negotiating with the examiner, narrow down those claims right up to the boundaries of the prior art on all sides. That way we have a demonstrated history and also a much better sense that we have claimed all of the territory that you could get and not left a bunch of room for people to design around. So with patents in particular, prior art rejections are desirable, and when we don't get them, it's not a good thing. It means that we may have left, or probably have left, some material on the table. With trademark applications, it's a little bit different, but they're not necessarily good in that way. But with trademark applications, increasingly they're becoming a normal part of the process. Even with copyright applications now, we're seeing more pushback, partly because of AI. But in both cases, in all three cases, what the rejection really is the examiner is doing their job. They are supposed to push back a little bit where they can, because if you think about it, in the case of a trademark in particular, unlike patents and copyrights, trademarks never expire. The registration eventually, you have to renew your registrations, but you can renew them forever as long as you're using the trademarks. So they're very sensitive about just granting these monopolies to, without any kind of challenge. So they are doing their job. They are not telling you it's over. Don't get hung up on the word rejected or rejection. It is just, it has a legal term, and this is part of a negotiation. I have a visual I do that explains this part as the negotiation between the examiner and the applicant's attorneys, because that is literally what it is. So anyway, I hope that helps. We do this all day long. We have gotten many, many, many things past rejections. The only time we really, the worst case scenario is when we believe that we can actually get past the rejection, but the client gives up because they get discouraged. So when you're starting out, plan for the whole process. Don't plan that the application is going to be the whole cost and it's just going to go straight through, because that's not very likely. Even with trademarks, it's better to plan ahead. And trademarks will sometimes go straight through, but increasingly that's less and less common. I hope that was helpful. So if you get rejections, don't despair. You're just going through the regular process. Again, it's the middle of the process, not the end. Hope that's helpful. Catherine Cavella, IP Works Law.